Thanks everyone for coming this evening and braving the weather. Last count, 60 mils have fallen in the last 24 hours and we're expecting more, so it's a sodden day. My name is Matthew Zagor. I'm an associate professor here at the ANU College of Law. I'm also the director of the Law Reform and Social Justice program, which I'm going to talk a little bit about in a moment. But I thought I would start by acknowledging that we are, of course, meeting on the traditional lands of the Ngunnawal and Ngambri peoples. I pay my respects to their elders, families, and forebearers. Sovereignty over the land and waters of Australia was never ceded. Treaties are yet to be negotiated, and the work of reconciliation remains of vital national and even international importance. Social justice, which lies at the heart of the ethos of the ANU College of Law, must start with the imperative of Indigenous justice. So the Law Reform and Social Justice program is the primary vehicle through which the college implements its commitment to these values and these principles. And in no small part, that's achieved through the work of our students, who are given opportunities to engage in research, lobbying, advocacy on the important social and environmental issues of the day. Working under supervision, they write law reform submissions and blog posts, op-eds, they organize and share expert panels and screenings, they assist peak human rights and community-based organizations, and they get to see their work have real impact. When students choose to do a law degree, this is often what they imagine they're going to be doing as lawyers, but the LRSJ gives you the opportunity to do this while you're still a law student. You can get involved in these projects even in your first year, in your first weeks. We will provide the training and the supervision and the opportunities for you to realize your ideas in this space. One of the flagship LRSJ projects that provides these opportunities is the Research Hub. And the Research Hub consists of students who every semester will identify a set of parliamentary and other inquiries upon which to make submissions. So these will range from inquiries on Indigenous heritage of the Juukan Gorge and the religious freedom bills that I think have all been put to bed, at least for the time being, with the new government, the powers of the AFP, counter-terrorism reforms. And in March of this year, Andre Kwok, Grace Sun, and Daniel Marns, who are all members of the Research Hub and ANU law students, decided to make a submission to the Joint Standing Committee on Treaties, JSCOT, on the agreement reached in January between Australia and Japan concerning, this is the official title, the facilitation of reciprocal access and cooperation between the Australian Defence Force and the Self-Defence Forces of Japan. Not certain we can make an acronym of that, but it's we're going to hear more about it shortly. They're going to explain how that treaty impinges on important environmental and human rights concerns, notably the death penalty, which the students brought to the attention of the committee in their submission. Now, I'm sure many of you are aware, especially if you've done international law, JSCOT was established in 1996 to examine and scrutinize all the proposed treaties which Australia has negotiated before ratification, right? So in other words, this is an opportunity for the public, for Parliament, for law students to have input before the treaty becomes binding in international law. Now, it's worth noting that the inquiry lapsed when the committee technically ceased to exist at the dissolution of the House of Reps before the last election in April, but JSCOT's become a permanent feature of parliamentary practice. So we expect the committee will be re-established. We expect that the new government will want to continue where the last government left off when it came to the treaty, and that the committee will proceed to consider it before ratification. The issues raised by the students, I'm just going to focus very briefly on the one that I'm most familiar with, and that's the death penalty. It's particularly topical in our region where 90% of the world's executions take place. And we've seen significant successes in the campaign to abolish the death penalty globally, but it remains on the books and in practice in too many jurisdictions, including Japan, which just last week carried out its first execution of the year by hanging Tomohiro Kato, who at the time was actually in the process of requesting a second retrial. So it was inconsistent with international good practice in this area. I also note that the UN Human Rights Office on Tuesday deplored the hanging in Singapore of 2 men convicted of drug trafficking, and they raised concerns that 2 other men are expected to be executed on Friday, which is tomorrow. So I'm honored that we're also going to be joined this evening by one of the nation's leading experts on the death penalty, Associate Professor Mai Sato from Monash University Law School. Mai is the inaugural director of Elios Justice, which works to restrict and abolish the death penalty in the Asian region. She's worked on projects in Japan, Malaysia, the Philippines, India, Kenya, and Zimbabwe. Our first speaker is going to be, however, my colleague, Professor Don Rothwell. He's going to set the scene for the discussion. Don's one of the leading experts in Australia in international law, with a specific focus on the law of the sea, the law of polar regions, the use of force, and the implementation of international law domestically. He's the author of over 200 book chapters and articles and 27 books. I'm not certain, Don, whether that includes the book that you published this week on the status of islands in international law. Like the students, both Don and May put in submissions to the parliamentary inquiry. Don's going to be followed by our 3 students. I'll just introduce them quickly. First, we will hear from Andre Kwok, who's going to be zooming in from Singapore. Andre's an Asian Studies and Law student. He's a Westpac Asian Exchange Scholar, an associate editor at New Mandala, which is a scholarly blog based at the NU Coral Bell School of Asia Pacific Affairs. We'll then hear from Grace Sun, who's a law and PPE student and a content editor for the LSS's Peppercorn magazine. She has a strong interest in environmental law. And finally, we'll hear from Daniel Marns, who's a law and philosophy student with an interest in issues surrounding public law and ethical philosophy. So without any further ado, I'm going to hand over to Don.
Thanks, Matthew, and good evening, everyone. Thank you, Matthew, for reminding me of islands and international law. I hadn't thought, May, when I put in this submission, but I do write about Ireland, Japan in my latest book. I won't be speaking so much about islands and international law this evening, but my task is really to sort of set the scene in terms of alerting you to a range of issues that come up with respect to the Reciprocal Access Agreement, and then I'll allow the other speakers to unpack and develop those issues in much more detail. So as Matthew said, the RAA was concluded between Australia and Japan at the start of the year, and it's a form of status of forces agreement, the acronym that those who work in the area commonly refer to them as SOFAs, but this is a slightly different SOFA, using that generic term because this particular instrument addresses multiple international and national legal issues associated not only with the exchange of forces between the 2 countries, including land, air and sea forces, and the associated civilian component. And it also allows Australia and Japan to build a deeper defence relationship. So it's a little bit deceptive in terms of saying, well, it's just a technical agreement between the 2 countries in terms of access. It's really a significant aspect of Australia and Japan building a defence relationship. So the agreement was concluded simultaneously in Canberra and Tokyo on the 6th of January, and it reflects the outcome of long-standing negotiations between the 2 countries over the finalisation of such an agreement, which had been partly delayed by the pandemic. A number of contentious issues associated with the agreement had become evident in the public domain as a result of material that was released into the public domain during the negotiation process. And there was a awareness, I think, on the part of the Australian government about the way in which civil society and academics such as myself might respond to some of those issues. So as I've said, the RAA is a form of status of forces agreement. It allows principally for the exchange between Australia and Japan of military forces and of an associated civilian component, referred to collectively in the agreement as visiting forces and civilian component. And the agreement seeks to resolve a number of international and domestic legal issues that arise when military forces and civilians accompanying them are exchanged. And it's designed to provide a pathway for ongoing exchanges over a long period of time. These types of agreements are exceptionally common for militaries which engage in high levels of interaction, and it needs to be observed that Australia has got quite a bit of experience with status of forces agreements. On the other hand, Japan does not have the same extensive experience as Australia with status of forces agreements. And to date, the only equivalent agreement that Japan has concluded is the 1960 agreement relating to the status of United States Armed Forces in Japan. Though that agreement does not contemplate Japanese forces being located or stationed in the United States. The Japanese Ministry of Defence announced late last year that there's also a Japan-UK RAA also under negotiation, and I haven't checked on the latest status of that. So at one level, the RAA follows a sort of template approach to what I've called SOFAs, or status of forces agreements. And if you cast your eye over the various provisions, there's a lot of aspects of it that are fairly common to these status of forces agreements, dealing with entitlements and obligations of persons who are subject to the exchange arrangements, a whole range of fiscal laws, access to facilities, questions concerning vehicles, driver's licenses, even most obviously military activities, weapons that are used as a result of those exchanges, and also oversight by the relevant command structures. So there are 29 substantive articles in the RAA, but in addition to that, and this is the interesting treaty law perspective, Matthew, which I guess really sparked my interest, there's an annex to Article 21. There is a set of agreed minutes to the agreement, and then most exceptionally, there's a record of discussion with respect to Article 21 of the instrument. So this record of discussion, in my view, is an unusual feature of this agreement. And I've given it some separate consideration in the purposes of my actual submission, which you can read on the website of the Joint Standing Committee on Treaties. I'll make an observation, which is another important aspect of this, and May might want to turn to make some comments on that. The agreement concludes by saying that it's done in duplicate in Canberra and Tokyo on the 6th day of January 2022 in the English and Japanese languages. Both texts are equally authentic. Now, that provision is not exceptional, and it's entirely consistent with Article 33 of the Vienna Convention on Law of Treaties, which recognises that if bilateral treaties are done in different languages, both language is equally authentic. But when there are two equally authentic versions of a treaty text in two different languages, there arises a possibility that different interpretations may occur between those two versions of the treaty. And there are many examples of that having occurred over time. And that immediately raises the possibility that there could be a potential for disagreement between Australia and Japan over differences in interpretation of the English language version and the Japanese language version of the treaty. And this is particularly relevant with respect to those aspects of the treaty that are unclear or are ambiguous. And in my submission to the Joint Standing Committee on Treaties, that was ultimately my conclusion on some core points. So with those introductory remarks, I'll hand over to the next speaker.
Hello, everyone. Before I kick off, I would like to thank Izzy and Jess from the LRSJ Research Hub for providing the platform to author this submission. I'd also like to thank Dr. Rothwell, Sato, and Zego for making tonight's event possible, alongside with the event organizers for supporting my participation virtually from Singapore, where I'm currently on semester exchange. My section looks at some of the issues associated with broad and imprecise terminologies in Article 21, Section 3B. This section details offences that would be subjected to criminal jurisdiction of a visiting state, so in our case, in Japanese territory. This section lists terms and uses language like offences relating to the security of the state, treason against that party, sabotage or espionage, or a violation of any law relating to official secrets of that party, and secrets relating to national defence of that party. These definitions create shades of grey due to the inherent proximity of visiting forces to military operations and intelligence, thereby creating an uncertainty about what military activities could amount to unintentional criminal offences in other jurisdictions. This is important because not only this creates issues of jurisdictional capture, but these listed offences in this section are also quite political in addition to being legal issues, potentially widening the scope for activities that may undermine security ties between Australia and Japan. So going forward in my section of the submission, I explore two key issues, treason and secrecy laws, alongside unpacking our recommendations. Australia and Japan have different treason legislation that vary significantly in terms of depth and detail on what activities precisely constitute treason. Section 80 of the Australian Crimes Act detail activities that result in treason include undertaking an act preparing for war against the Commonwealth and engaging in activities that harm or kill the sovereign's heir, governor, general, prime minister, etc. In the Japanese context, the closest definition of treason lies in Section 2.81 of the Japanese Criminal Code, which simply mandates the crime of foreign mischief. This definition lacks a clear definition and is a topic that is debated in Japanese legal communities. I also did a little bit of research on Japanese sites to see if there was any clarity or any light that could be shed on this, but the consensus seems to be the same on how there seems to lack a clear definition. Moving on to the secrecy laws, Australian secrecy laws are mandated in Section 70 of the Crimes Act. Section 70 does not create a duty to keep information secret or confidential. Rather, the source of such duty must be found elsewhere, so most commonly in a specific secrecy provision. But coming back to the RIA context, the key issue is a bit of a clash with Section 79 of the Crimes Act that mandates a list of prescribed information that would amount to a criminal offence. Such prescribed information includes communicating or allowing someone to have access to or retaining an official secret without authorization with the intention of prejudicing the security or defence of a Commonwealth. However, coming back to the RIA, the Crimes Act does not provide guidance on handling information, like practically handling the information that could involve the disclosure of secrets in a cooperation, defence, bilateral context like the RAA. In Australia, this act highlights the procedural elements of the information rather than what information itself constitutes a breach under this section of the RAA. If we look at it in the Japanese context, the Act of the Protection of Specially Designed Secrets governs the country's secrecy legal regime. In contrast to Australia, this Act mandates three categories of special secrets. So the three are defense, foreign affairs, and terrorism, which information related to those must be safeguarded from public disclosure. This Act notes that defense, information, intelligence, and research concerning weapons, ammunition, aircraft can constitute breaches of this Act. The Act goes as far to underscore that uses of special secrets in matters of territorial integrity, or the peace and security of the international community, especially constitute an unlawful emission of special secrets. I hope I'm painting a really clear image of the crux of this matter, the issue of clarifying almost like the tension, boundary, pressure points on what counts as treaty of secrets when a foreign nation, so in this case, Australia, are at the same time mandating such highly interconnected, interwoven military activities, which could easily trigger these offenses. I'd also like to briefly look at some of the contextual background of the Japanese criminal system that might assist us in understanding this matter in more depth. Breaches of treason and secrecy legislation could amount to consequences in the Australia-Japan relationship. So Japanese legal scholars have widely criticized the Japanese criminal justice system for breaching judicial independence and upholding a presumption of guilt in criminal investigations. And this has been coined as hostage justice, or hitojichi shiho in Japanese. So police and prosecutors in Japan can detain suspects for 23 days without bail in substitute prisons. These concerns are exacerbated by the frequency of prosecutors often extending detention periods by filing charges and splitting them into multiple crimes. Under Japanese law, suspects do not have the right to legal counsel, together with instances of denied counsel services when foreigners get detained. This has raised concerns that these practices have raised concerns on breaches of constitutional freedoms, including right to a speedy trial and freedom from self-incrimination. Like Dr. Rothwell's submission highlighting Australia's clear position of abolishing the death penalty abroad, these issues associated with due process are also topics that Australia has been highly vocal about in the international community. Australians have also been subjected to hostage justice in the past. So with issues surrounding treason, secrecy laws, and the brief context of the Japanese criminal justice system, our submission recommends a Memorandum of Understanding, MOU, between Australia and Japan to clarify and formalize a legal framework that harmonizes the definition of the list of offenses under Article 21. The advantage of adopting the MOU approach as a subsidiary instrument is that they can enter into effect without legislative approval, offering some more agility and flexibility to adapt the existing agreement. The expected result of introducing this recommendation is a harmonized understanding of these definitions of what offenses mean what, and address the ambiguities that will likely arise due to the unavoidable proximity of military activities in each other's respective military apparatuses and infrastructure. We suggest that implementing this MOU could be modeled after existing MOUs in bilateral treaties, including the MOU between the Government of Australia and the Government of Nauru on the Development Cooperation Program, and the MOU of Understanding between the Republic of Indonesia and Australia on cyber cooperation. So yeah, so those are some of the key points, and I'll leave it for there now. Thank you.
Thanks, Andre. So I focused mainly on the environmental aspects of this treaty, and we mainly focused on two. The first one is in terms of clarifying the requirements that it lists out for environmental protection. And the second one is in terms of encouraging more maritime domain awareness. So with the first one, we recommended that we should probably clarify the requirements for protection of the environment that they talk about in the treaty in Article 20, and perhaps assess them against the current domestic environmental responsibilities of both Australia and Japan. So basically, we thought it was unclear in Article 20 whether members of the visiting force would be subjected to the environmental laws of the receiving state, as Japan and Australia have slightly differing standards of environmental protection requirements in certain aspects. So it would be probably important to determine whether the environmental protection requirements of the sending state are at a higher or lower level than the receiving states. And so, for example, under Australia's Environment Protection and Biodiversity Conservation Act, or the EPBC Act, it lists out 9 matters of national environmental significance that it protects, which includes the Commonwealth marine areas. And similarly, Japan has what what it calls its basic environment law that determines the fundamentals of the specific provisions of the various individual environmental laws that exist in Japan. And so I thought it should be clarified whether the operation of the visiting force, as stated by the treaty, should be in a manner consistent with the protection of the environment, and whether that needs to be congruous with domestic environmental responsibilities as well. And once that's determined, we also thought Article 20 should clarify how the enforcement of environmental obligations would be regulated. So in Article 20, although it states that the sending state shall address any damage or potential damage to the environment promptly, coordinating with the receiving state and in accordance with the laws and regulations of the receiving state, it doesn't actually mention how compliance will be ensured. And whether or not like violations of the environmental laws would result in sanctions. So in Japan, for example, regulators tend to seek voluntary compliance with environmental laws before they actually exercise their compulsory authority. And similarly in Australia, the EPBC Act includes criminal and civil penalties for breaches of its provisions. And then when the Australian government does investigate into compliance with the Act, it would generally consult with the relevant local authorities first as well. So yeah, in Article 20 only states that any damages caused by the sending state will be addressed, but it doesn't mention how compliance will be monitored and regulated. So currently it's probably assumed that if any disputes were to arise concerning the implementation of environmental protection measures, the parties will aim to resolve them through consultation and negotiation, which I think is mentioned somewhere in Article 28. But since the requirements for environmental protection are not clearly stated, and there's no mention of compliance ensurement measurements, we thought it'd be important to clarify the way in which the environmental obligations would be enforced and whether or not sanctions would be issued when or if the receiving state's environmental laws are violated. So that's sort of the first issue for environmental protection. The second one relates to increasing maritime domain awareness, or MDA for short. So as I previously mentioned, one of the 9 matters of national environment significance protected under the EPBC Act is Commonwealth marine areas. Since the Indo-Pacific is primarily a maritime environment associated with maritime security and cooperation, we also recommended that within the requirements for protection of the environment, reference should ideally be made to Australian and Japanese cooperation on increasing maritime domain awareness, or MDA, because it's very important to national security and it has significant economic and military implications, especially for Australia and Japan, who are both Quad members as well. So enhanced information sharing and cooperation with encouraging greater MDA between Australia and Japan is quite important to promoting the peace and stability of the Indo-Pacific region, which comprises important sea lines of communication. Australia, being the 5th largest shipping nation in the world in terms of like tons of cargo shipped and distance traveled, has strong economic and national interests in maintaining civil maritime security within and beyond Australian waters. In Australia, the Maritime Powers Act provides enforcement provisions for all maritime law enforcement matters, and any maritime operations both in and beyond Australian waters has to be carried out consistently with international as well as domestic law. And similarly, Japan is obviously also surrounded by the sea, so it's also a maritime nation and has the world's 6th largest exclusive economic zone. So both Australia and Japan as maritime powers are highly dependent on free and open ocean access. So it is in their interests to maintain safety and security in the international sea lanes, because that can also minimize threats to national security. In the 2020 Guide to Australian Maritime Security Arrangements report, it listed 8 key maritime threats faced by Australia, including irregular migration, illegal exploitation of natural resources, marine pollution, illicit trafficking, compromises to biodiversity, piracy, and maritime terrorism. And that Japan similarly also identified its threats, including frequent marine accidents, marine pollution, and illegal unreported management and unregulated fishing that was undermining the effectiveness of its resource management. So yeah, the national security interests of both Australia and Japan would likely benefit were they to cooperate in strengthening each state's MDA. Additionally, Australia, if we were to help strengthen Japan's MDA, we would effectively also expand our own scope and reach of our own MDA effort, which has consistently been limited in its geographic reach, given the size of Australia's maritime area of responsibility. And MDA is a critical platform and framework for sharing maritime information between Australia and Japan, as it does have the ability to affect national level issues like security, safety, and the economy, and being a crucial element in response to various ocean threats, whether they're man-made or natural. So yeah, we recommended that within Article 20's requirements for protection of the environment, reference should probably be made to encouraging Australian and Japanese cooperation on increasing maritime domain awareness in an effort to minimize national security threats via sea lanes. So yeah, those are the two main aspects or environmental aspects of the treaty that we talked about. And I'll let Daniel talk about the rest. Thank you.
All right, so yeah, in my section of the submission, I focused on the death penalty. I think it's just to give some context. The treaty, at least as far back as we could see in news reports, has been in discussion since 2014. So it's been debated and contested for a while. And it seems to be the primary reason for that was the death penalty issue. So Japan sort of, in previous agreements like this, there has been controversies surrounding jurisdiction. Donald brought up the status of force agreements between America and Japan, and that's resulted in controversies before where a US soldier will commit a crime in Japan, but will ultimately be tried in the US. And on the other hand, Australia has sort of a public position on the death penalty in the Asia Pacific to encourage its elimination, its removal. So ultimately that was kind of one of the primary issues that slowed down the progression of this treaty. And since it's finally been agreed upon by both parties up to this point, we tried to frame our submissions on the death penalty point in such a way that gave account for the diplomatic effort that has been put in so far since 2014, and trying to make them sort of somewhat feasible, given both countries have publicly supported the agreement so far. So yeah, so the way the jurisdiction works in the treaty, like who has jurisdiction over criminal crimes, Article 11 outlines that the laws of the receiving state will apply to members of the visiting force for criminal offences. So yeah, so if we send troops to Japan and a crime occurs in Japan's territory and it's a criminal offence, Japanese laws will apply. And then there are some provisions regarding sort of concurrent jurisdiction. So, and in aspects where there is concurrent jurisdiction, which would be a scenario like that, such as, like a criminal offence occurring on base, where it's both Australian and Japanese jurisdiction. It's stated in, also within Article 11, that ultimately, in almost all cases, except for a few exceptions, that the receiving state's jurisdiction will prevail. So Japanese criminal law will prevail there, except for some exceptions such as sort of like damaging Australian property and the like, where it wouldn't make much sense to apply Japanese sovereignty and Japanese law. And then Australia has international obligations under the second optional protocol to the International Covenant of Human Rights, which obliges Australia to not allow the death penalty to be imposed within Australian jurisdiction. So then there's this sort of somewhat strange scenario where there's a concurrent jurisdiction between Australia and Japan, yet Japanese law will prevail, where Australian soldiers could be subject to the death penalty in that concurrent jurisdiction. And yet we have international obligations to prevent Australians, or just those within our jurisdiction, to be subject to the death penalty. So that's kind of the key crux of the issue here. And ultimately, there is no prohibition in the treaty for members of the ADF to not be subject to the death penalty, but it does sort of discuss it in a somewhat convoluted way. So within section 11 of the treaty, there is a section requiring the sending state, so Australia, if we were to send troops to Japan, to help the receiving state in their investigation for a criminal offence trying a sending state civilian or troop. So if we sent someone to Japan and they were committed a criminal offence and the Japanese authorities would investigate, we would be obliged under the treaty to help them provide witness statements and the like. And then in the annex to the treaty, which is a part of the treaty, it stated that we would not be obliged, the sending state would not be obliged to provide help to the receiving state to prosecute a member of the sending state if it is likely it would not fulfill our international obligations. So in a sense, that is clearly referring to the death penalty, where if one of our troops is potentially prosecuted under Japanese law and there is a potential for the death penalty there, we would not be obliged under the treaty to assist them in their investigation when we otherwise would be. And then in the record of discussion for the treaty, which is not a part of the treaty, unlike the annex, it stated that that section of the annex is indeed referring to the death penalty when it says our obligations under international law. So there's obviously an issue with how the treaty is structured here. It's unclear why that aspect of the record of discussion referring to the death penalty could not simply be in the treaty itself, as in within the annex or the treaty, the main body of the treaty. But ultimately, the core issue is that there is no protection for Australian troops being subject to the death penalty. So then, as to our recommendations, we submitted 3 recommendations in sort of differing levels of diplomatic feasibility and actual effectiveness in preventing the death penalty from ultimately being used. So the first one would be simply inserting a section into the treaty stating that in case of criminal trial, there will be no imposition of the death penalty. Now, it seems like this is fairly unlikely to occur, given the treaty has been in debate since 2014, and that's been the primary issue, and the parties have not been able to reach an agreement. So that would obviously be the ideal outcome for an alteration to the treaty, but it's simply likely infeasible. And there is some historic sort of precedent for this. There was a recent similar treaty agreement between the UK and Kenya, where Kenya sort of allowed that kind of section of the treaty, which simply stated, members of the sending state shall not be subject to the death penalty. In that treaty, Kenya allowed that. However, again, it seems like it'd be unlikely to ultimately occur here when both parties have endorsed the version of the treaty that does not include such a provision. And then there was one alternate, there's two other alternate suggestions. One would be to put a sort of a penalty limit on the potential sentence a sending state troop or civilian could be imposed under the receiving state's law. So, and in introducing a section within the article that imposes that. So, for example, including a section that essentially states if someone from Australia is to be prosecuted under Japanese law, the maximum offence would be the one that could be imposed for the equivalent crime under Australian law, which has the kind of advantage of that it doesn't explicitly prohibit a sentence which is only available in Japan, and thus sort of clearly being targeted directly at Japan, when the rest of the treaty is worded in such a way that's clearly intended to be very neutral. However, it also could kind of have potential negative side effects, such as like smaller crimes such as theft, where the difference in potential sort of outcome varies quite widely between Japan and Australia. And then the final suggestion, which is sort of the most feasible, but also the least useful, is the introduction of a less than treaty status, so not within the treaty, but some sort of memorandum of understanding that the sort of both parties will endeavor to ensure that the death penalty, or all reasonable efforts will be made to not impose the death penalty, which would go beyond what is there currently. Currently, again, really all that can be found is the annex and the discussion, the record of discussion, which prevents Australia from needing to help a trial process in Japan if there was to be the potential of a death penalty, including perhaps another section in the record of discussion, or a separate memorandum of understanding that just sort of noted that both parties would endeavor to prevent the death penalty from being utilized, would sort of be a better alternate option to what is currently there, but would ultimately not be binding on either parties, and thus the other options would be preferable. But it seems unlikely, given the political climate, that they would actually eventuate. So we've provided a range of recommendations depending on what's feasible. Yeah, that concludes my section. I'll hand over to Mai.
So thank you very much for ANU Law and Law Reform and Social Justice for having me. When we saw the ANU submission on the government website, and also Monash, Elios Justice, together with 3 other organizations, also made a submission. But I think Daniel has described the Reciprocal Access Agreement in relation to the death penalty. So what I'm going to do is 2 things. I'm going to talk broadly about the Japanese death penalty system. And then second, I'll talk a little bit more about the 2018 Australian government's strategy against the death penalty. I think that's the only difference between our submission on the death penalty and the ANU submission on the death penalty. So I'll start with the Japanese death penalty. So Japan obviously has the death penalty and execute prisoners every single year. You will see on the PowerPoint that 2020 was the exception of no executions, but that was the year when Japan hosted the Olympics, and also that was the year that Kyoto in Japan hosted the UN Congress on Crime. So it's not a surprise that there weren't any executions that year. And as Matthew mentioned, last year there was an execution in Japan. So there's 19 capital offences in Japan. Under international standards, death penalty is permissible for quote unquote most serious crimes. And the UN Human Rights Committee has defined most serious crimes as intentional killing. So applying that to Japanese criminal law, 18 out of the 19 offences don't meet the requirement of international standards. So there's 19 capital offences, and as you can see in the slide, the method of execution is hanging. You will see 3 or 4 people on the upper level. Those would be prison guards. When an execution happens, these prison guards will be given a button, and they will all press the button at the same time. And one of the button will open the trap floor. So we do this because we don't want the prisoner guard to know which button actually activated the trap door. So this, what you see on the slide, is the unofficial illustration. That was all that was available until 2011. So this is not published by the Japanese government. And then in 2011, the then Minister of Justice made a one-off exception to let TV camera crews go inside an unused execution room. And that was the only time when we could actually see an execution room. Next slide. So this is the photo of an unused execution room. When an execution happens in Japan, death row prisoners are notified on the day of the execution. So they're only notified a couple of hours in advance. And what that means is that there's not enough time to get in touch with their legal representatives to challenge the execution, and families will be notified after the execution's taken place. And the government has justified this practice by saying that giving a lot of advance notification would not be good for the prisoner's peace of mind. That's the phrase they use to justify their practice. Currently, there are 109 death row inmates, and they are all kept on in solitary confinement. So this is what a solitary confinement cell looks like. It's normally just 3 tatami floors, so it's just enough to stretch out a futon. And in this photo on the right, you will see a white mark. That is the sink, and next to that would be the toilet. So it's a very small room. So death row prisoners would be in solitary confinement for up to 23 hours a day. But they are allowed 1 hour of exercise. So this is a photo from Tokyo Detention Center. Under Mandela rules, prisoners must have access to outside exercise. And this is how the Japanese ministry interpreted that international standard. So it's not outside on the ground, it's on the rooftop. And what you see in the main photo, that corridor is not where they exercise. That's where the prison officers walk up and down. And below that are these individual cells, and they are smaller than their solitary confinement cells. So it's probably only enough to walk 1 or 2 steps and 1 or 2 steps back. And that's where they get their 1 hour of exercise. Confidentiality of meetings between lawyers and the death row inmate and family members and death row inmate is often not guaranteed. So this is a very typical meeting area. You have a glass separation from the table all the way to the ceiling. So if a family member visits, they wouldn't be able to hug or touch each other. So you have on the other side will be where the prisoner will sit. And here you see 2 chairs, and on the nicer cushiony chair is where the prison guards will sit. And then on the not so nice chair, that's where prisoners, including death row inmates, would sit. And often the prison guards will be taking notes of their discussion. So that's the overall sort of overview of the death penalty system in Japan. And what characterizes the Japanese death penalty is secrecy, as you can see from the method of execution, as well as we don't know the selection process of who gets executed next. And we also know very little about the treatment of death row inmates. So that's the death penalty system. I'll just add a few words on the Australian strategy. So in Australia, DFAT announced a 2018 strategy on anti-death penalty, and that is a policy that states that the Australian government will oppose the death penalty, quote, in all circumstances for all people. And the strategy also says that Australia will be a leader in efforts to end the use of the death penalty worldwide. This makes Australia different to other abolitionist governments, and I categorized there's 2 types of abolitionist governments. One type of abolitionist governments are governments that have abolished the death penalty in law and practice and have ratified relevant international treaties, namely the Second Optional Protocol for Civil and Political Rights. And what that means is that they can't execute in their jurisdiction, but they also cannot extradite individuals that may be subject to the death penalty. So that's one category. And I would put Australian government in the other category, which is that they're abolitionist in law and practice, ratify the international treaties, and have a strategy or a policy to promote abolition worldwide. And those governments include UK, Norway, and they're not governments, but EU as well. So they are an advocate for death penalty abolition. So taking that into consideration, one could justify the RAA to say, oh, the death penalty, it's a remote hypothetical, or that the government has made has negotiated this, and this is a reasonable compromise. But the Australian government has published this 2018 strategy, which takes a very principled stance on this issue. So on that point, I think compromising on the RAA with Japan in this situation, I think is a very much of a missed opportunity. Australian government could have influenced the Japanese death penalty policy, and we call this in sort of death penalty literature as indirect abolition of the death penalty by a third country. And I think this really was a missed opportunity. And I think the unintended consequence could be that it could actually undermine the anti-death penalty movement with governments such as Norway, UK, France, and the EU, and that it could entrench death penalty practice by a small number of retentionist states, sort of feeding into the narrative of national exceptionalism and so forth. So I think this was a very missed opportunity by the Australian government, given they have the 2018 government strategy. Now, post-election, I guess this is the former government strategy, but I see no reason why the Australian government would not continue with a similar policy. I'll just end by saying that this 2018 strategy has really had reputational benefits for the Australian government. It was published in 2018, so 3 years after Chan and Sukumaran's execution, which allowed the Australian government to portray a new image as anti-death penalty advocate. And also around the same time, the government was campaigning to have a seat at the UN Council, and the anti-death penalty campaign was central to their campaign to get a seat on the UN Human Rights Council. So now I think what is needed by the Australian government is not just to have the strategy, but actually to act on it. So thank you.
Thank you everyone for your contributions. Apologise for having to run out. I actually missed the first 1.5 with a coughing fit. However, I am still within my 28 days, so I shouldn't be infectious at all for COVID. I know it's disconcerting when anyone has a coughing fit over the last 2.5 years. I'm going to open up to the floor for some questions. I have some of my own, but I thought I'd start with any that we may have from the people on the floor. We also, if you wanted to ask questions more broadly about the LRSJ or a little bit more specifically about the Research Hub, we have one of the team leaders here to answer questions about that as well. So any questions from the audience members? Well, I guess I could, but right, one question here.
My question's from Mai. How do in Japan, is the death penalty largely supported by the Japanese population, or what's the general attitude towards the death penalty in Japan?
So the Japanese government justifies the retention of the death penalty by claiming there's majority public support, and the government carries out their own survey every 5 years. And the main survey question asks people's support for the death penalty. But if you ask the general question, the public, you normally get around 80% support. But what the Japanese government doesn't publish is that in that survey, they also ask about people's, whether retentionists would consider future abolition, would they support abolition if life imprisonment without parole was introduced. And if you reanalyze those various questions and try to recalculate who are the committed retentionists, it's only about 36% or so. I've also carried out surveys on the death penalty in Japan. And if I use the same wording as the Japanese government survey question, which is a very problematic wording, then I'll get a similar result using a similar sampling method. But then I ask the so-called retentionists, what if the government decides to take leadership and abolish the death penalty? 70% of the so-called retentionists say they'll just simply accept as government policy. So in a nutshell, yes, the Japanese government justifies its retention based on majority public support. But I think in reality, the Japanese people, perhaps as a default, you live in retentionist states, and if there's a heinous crime, people call for the death penalty. But when you probe people with further questions, I don't think Japan is a society where the legitimacy of the justice system hinges on the government retaining the death penalty.
I was going to pick up on the death penalty theme a little bit. As Daniel, you said that the first recommendation that you would have would be to actually insert prohibition into the treaty, and then you had the sort of scaling down your expectations from that point. But you also said that it was your understanding that since 2014, this treaty had been negotiated and that this was a sticking point. Is that something we're aware of, that we know about?
It seems that that was I'm not sure if either government had made public statements as to the effect of this is the delay in the creation of the treaty, but articles from experts on the topic seem to agree that that was the predominant, or that at least would be the predominant sort of sticking point and issue with the creation of the treaty.
In terms of getting amendments to treaties that have already been negotiated, I'm just wondering, Don, in your experience, when Scott has looked at a treaty before ratification and has come up with strong recommendations that you go back to the negotiating table, do they do that to start with? And I suppose if they do, has it ever resulted in any significant return to the negotiating table?
Thank you for that, Matthew. One of the fundamental problems with the processes is by the Parliament, and which the Joint Standing Committee on Treaties has to live with, is that the committee is faced with reviewing treaties that have already been negotiated. And so at one level, the committee has a black and white option: ratify, not ratify. There's been only a very, very small number of instances where not ratify has been the recommendation. And when ratification is recommended, there's a number of useful aspects of that which can go to a whole series of matters in terms of policy, can go to matters associated with implementing legislation. The most difficult element of a recommendation that could come from the committee is precisely the one that you've made, and that is that a treaty should be renegotiated. That could extend to a particular article or quite a number of articles. So the problem is, of course, is that the treaty is a done deal. And so going back to renegotiate the treaty could be diplomatically and politically very difficult. In this case, however, there's been a change of government in Australia, and indeed there's been a change of government in Australia. So that could provide the current government, if there was such a recommendation made by J. Scott, to actually go in good faith to Japan and say, well, look, there are some aspects that we'd like to revisit. And it may not only just be the death penalty aspect, but there might be others. So that's a somewhat unique aspect of the political dynamic that's arisen as a result of the change of government, and possibly could open the door for a renegotiation of some, at one level, minor aspects of the RAA.
Thank you. My name's Nathan Kenzie. I'm an officer with the Attorney General's Department. My question is for Professor Sato, and it's about countries that have moved from being retentionist to abolitionist, and what you see as being the key factors in influencing that policy choice, and where pressure from other has been an important part in that. And my question arises in the context that the levers we have to pull to influence a country to move or to make such a significant policy choice are limited, and in fact can be counterproductive to having a country change its policy. So I'm just interested in knowing what causes a country to change its policy in this regard.
I think I'll start by saying I think there's two ways to movement, which is one is judicial leadership. So courts take the initiative in abolishing the death penalty, and that will be a very easy process. And then political leadership, I think changing government is one thing. And I think in the US, various states have indeed moved away from the death penalty. And I think that is two things: the innocence narrative that innocent people have been executed or sentenced to death, and then the discrimination angle that death penalty is arbitrary and it's a discriminatory system based on race. I'm not sure whether that is applicable in other jurisdictions. I think the innocence framework particularly worked well in the US because for decades, US has tried to create a quote unquote safe death penalty system. They have mandatory appeals, they call it Super G process. So even having built a so-called safe system, all these university-led innocence projects has managed to veil various ignoration cases. And I think that really shifted people's attitudes towards the death penalty. And I think it was more of a bottom-up sort of factor in states deciding that they need to move away from the death penalty. I don't see that happening in Asian countries, for example, where trust in the criminal justice system is already low and miscarriages of justice or wrongful conviction isn't much of a surprise, where they know there's police corruption, torture. So when we did some surveys, people's support for the death penalty existed separately to people's concern for wrongful conviction. So I think that's unique to the US. Others, I just wanted to pick up on the point that you made about speaking up against the death penalty to another country is often counterproductive. I'm not sure if that is the case. I mean, government of Singapore or Iran would openly say that, leave us alone, sovereignty, but that's not the same as saying that they don't care about what other governments say. Iran has also changed its practice on death penalty, and I think international pressure has helped. And when people are lined up for executions, people calling out has sometimes helped getting them clemency or having another appeal. So I think it does have an impact. One study I want to quote is one on Kenya, where we did a attitudinal survey and asked to the retentionists, so-called retentionists, to the so-called abolitionists, why do you think Kenya should abolish the death penalty? And the most quoted reason was Kenya should be seen as part of the international community that upholds human rights. So I think when governments start thinking about their international reputation, and I think that includes countries that already haven't executed, like Kenya for nearly 30 years, to those governments that are aggressively executing, like China, Iran, I don't think they are that immune to international pressure.
Question for you, Grace. You mentioned a range of threats to the maritime environment and Australia's list of issues that appear in the Maritime Security Arrangements Guide from 2020. A lot of those sounded like they would also have international treaties attached to them with international obligations. Did you look at how or to what extent Japan's international environmental Australia's overlap or gaps there?
Yeah, I looked at like Japan's environmental law and like how it was built, sort of, and they have what they call the I think the basic environment law, and then they sort of build all their environmental laws on top of that. And then I compare that, so the Australian main environmental law as well, and it seemed fairly similar in like the aspects that they covered. It was just sort of more in terms of the way they enforce that as well. It differed a little bit. Japan was more, I think, like looking for voluntary compliance before they like intervene and use their like authority to make stuff compulsory. Whereas I think Australia straight up just includes like criminal and then civil penalties if you breach their provision. So I think the aspects they cover in terms of the environmental laws fairly similar, but more in terms of like how they enforce
it domestically. And these would be based on treaty obligations in both jurisdictions as well, you think?
Probably.
Yeah. Interesting. Do we have any other questions from? Oh, we have one.
Thank you very much all for your comments. It's interesting to see how this treaty has been received in Australia and raises some issues that are important in this society, so clarity of law and environmental protection and the death penalty. You've also talked about kind of, suggested tweaks and things that might be able to be done from here, which I suppose would require further discussions. Are any of you able to speak to how the treaty has landed in Japan and what sort of conversations might be happening publicly in Japan about this type of agreement?
Yes, this agreement has been reported widely in the Japanese news, and the death penalty provision has actually been reported to say that death penalty is unlikely to be applied to Australian military personnel. That's been the dominant reporting in broadsheet papers and in other media. I mean, there are blogs and independent online websites that go into detail about the RAA, but for example, Asahi, Yomiuri, Nikkei, they all reported to say that Australian military personnel are unlikely to be executed. So they haven't misinterpreted, but they haven't really gone into the detail of the RAA. In fact, when I was speaking with the Japan Federation of Bar Association, they also had the same idea. And when I proposed that perhaps they should do a statement saying that, doing a statement on this issue, they felt they shouldn't be telling the Australian government what to do, even though the JFBA is an abolitionist organization now. So it's been reported, but it's not been there's not been a great deal of discussion. And I should probably mention that Don had this great idea of comparing the Japanese text against the English text. I haven't done that yet, but when we can do another submission under the new government, that's something we've discussed and would like to do.
I have a question for one of the students, if they would like to answer. Basically, I commend you for taking an interest in law and international relations and for, giving up your own time to do this. So I'm interested in what drew you in particular to look at this agreement compared to, say, some of the other treaties that were in the public domain.
Andre, would you like to take that question first?
Apologies. So what's the question? Why we chose to author a submission on this particular agreement? So, yeah. I think for me personally, my other degree is Asian studies, so I think it was just a really natural fit. I think personally, I've been interested in Japanese law and society for a while now, especially the idea of hostage justice. So I think looking at administrative law in Japan, in terms of separation between the executive and the judiciary, is something I've been following for a while now, and Japanese politics is something that I'm also quite interested in, and I've had the chance to explore it in my Asian studies degree, and it was really cool to have the chance to author a submission with my team.
Personally, because I was on the LRSJ Facebook page and they had all the polls for which submission you want to do, and then this one had like the least amount of people, I think, so I was like, okay, I'll look at this one. And I looked into it a little bit and it seemed, I guess, a bit interesting because I always wanted to visit Japan as well. So it was sort of just a random pick, but it became more like interesting as I read more into it and looked more into it. So yeah.
Yeah, and a pretty similar answer from me. At the time of, so there was the list of sort of different commissions and committees that were open for submissions and their particular topics. And this was the one that interested me the most. Although it was in some sense like a blind pick, because I hadn't studied international law when I selected it, and I'm only taking that course now. But of the sort of options of the particular committees that were accepting submissions at the time, it was the most interesting, and I picked it. And then it turned out to be a very interesting and in-depth topic.
So I'm one of the co-leaders for the Law Reform and Social Justice Research Hub. And so what we do is we help coordinate basically student groups to work on particular submissions to open inquiries. And in the lead up to the federal election, we noticed that there actually weren't a whole lot of open inquiries currently accepting submissions. So there was a slightly limited amount of choice, but we sort of have a look through inquiries both at the federal level, but also ACT, New South Wales, Victoria, whatever might look interesting and has a viable timeframe for our students. And so this was one of the ones which was open, along with one on the UN Declaration on the Rights of Indigenous Peoples and the UK-Australia Free Trade Agreement, for example. So a bunch of interesting submissions. And we have a Facebook group, which is our main source of interacting with students. We found that that's the easiest way to get in contact with lots of students. They do have an email address for people who don't have Facebook as well. And we post a Facebook poll basically saying these are the ones that are open at the moment. If you're interested, we can set up a group for you, a Facebook Messenger group with other students who've also selected the poll. So a lot of the students often don't know each other, and we'll try and help to set up a first meeting and do some brainstorming if needed and run through the basics of what a submission involves and what a parliamentary inquiry is, and really kind of help students. We have, first year students to final year students, so a really great breadth of knowledge. And so I mean, it's very much up to the students, and they deserve all the credit on this because they write the entire thing. But we just try and help where we can by putting students in touch with academics, or providing some editing at the end, and then uploading the submission to the parliamentary website. Yeah. If you're an ANU student, undergrad or postgrad, and you're doing law, you're very welcome to get involved. You're welcome to chat to me if that's helpful.
Thanks for that. And the academics who were involved in this particular one were David Letts and Rob McLaughlin. Is that right? No one consulted you, Don, on this time around? So there's academic guidance, and we also give training for writing of law reform submissions. But Research Hub students helping out those who are starting afresh, who may be intimidated by the whole idea of writing a law reform submission. In the last year, we've also had 3 different groups of students invited to give oral evidence before parliamentary committees, which of course is a whole other skill set to develop, but a really, really useful one, and something that we hope will maybe happen in this instance as well, because there were so few submissions. They got to invite us, I reckon. Any other questions? Yes, one over there.
Sorry, another processy question, I guess. I'm just interested in how you chose the issues that you wanted to focus on. You all chose very diverse and very complex issues like secrecy provisions and environmental impacts and the death penalty. So I'm just really interested in, one, how you kind of divided up between you, how you would, or what you would focus on as the substance of your submission, and also I guess what the clicking point was for you when you decided to make the recommendations that you did. Really interested to hear how you identified the issues.
Well, we sort of, the 3 of us, we just met up one day. And then I think we had a brief read over the treaty. And we all sort of just told each other what we had, like our ideas for what were the main issues that we could see. I think the one that obviously stood out was the death penalty. But then we also wanted to flesh it out and or flesh out our submission and have some other aspects when we looked into it. I think as we went along, we just spotted more issues. Like initially at the start, maybe we didn't have that many. And then as we were reading into it, or like writing into it, we sort of just found a few others to flesh out our submission.
I think we, after brainstorming a bit and meeting up for a few times, we had, perhaps 8 or 9 sort of separate issues that we might talk about. I can't remember what the ones that did not end up reaching the submission were. I think some were to do with like different types of weapons and that sort of thing. But as we divided the issues between us and then went to research them, we found that I think a lot of them were kind of duds. There wasn't a huge amount to say on them, or perhaps the committee wasn't the appropriate place for submissions on those points, or the treaty itself didn't really address those issues. And eventually, through that sort of filtering process, we were left with 3 core issues that we came to and addressed.
Yeah, not too much to add. And I think another thing that helped was, I think one of the other academics who consulted us in the planning process gave a lot of really great insights on pointing us on to the right direction, especially on the more technical elements, like what's an MOU and how's an MOU different to a different initiative. So I think the consultations and the advice from the other academics involved in the projects were super helpful.
It actually takes me to a question I wanted to ask you, which was a couple of the recommendations said you should have an MOU. And everyone, I think, knows a memorandum of understanding almost certainly won't be binding in international law. Why would you have chosen that as an avenue, for instance, to defining offences, which you say are the definitional problem of ambiguity? You think it's going to be clarified through an MOU. Why would you do it in that sense, as opposed to, okay, an amendment's going to be impossible because you can't renegotiate, but perhaps you could have lodging of an understanding, for instance, when the treaty is made, or even some type of additional protocol eventually that would flesh out some of these issues that would then be binding in international law. So why go down the MOU route, which was, I think, someone else had, I think also MOU when it came to the death penalty. Is that going to be sufficient to meet the problems that you've identified?
Yeah, so I think my understanding of MOU is that it's quite flexible and agile to make. So from the conversations I've had with, I forgot his name, which is really bad, one of the academics that consulted with us, is it's a really good starting point on trying to find some middle ground on some of the key definitions. And I think I remember from the agreement that it mandated some consultation processes. So I think it would be a really great launch pad in just coming up with pathways to more clear understandings, which may be helpful in crystallizing something further. And I think throughout the research that we've done, we've encountered research that Japanese authorities and governments tend to resist the more hardline processes that define stuff. So doing an MOU might be more helpful because it's more soft, which may be much more palatable for the Japanese authorities. But yeah, I think that's certainly one way, but I think we'll be open to exploring other tools and instruments if something else more useful comes up. But yeah, that's from me.
I think that's really interesting. I think it's really interesting that you were all aware of the nuances and the contexts within which you were operating, including, well, maybe we shouldn't put this to the committee. It's not the right venue to air these particular issues. Sometimes it's important to know who's sitting on the committee as well, who's chairing the committee, or even building a relationship with the secretariat and the secretaries. So all these little things that you don't think about when you're at law school are going to be part of the law creating and law reform process. When it comes to strategizing and pitching your message. The other thing that I thought I would add in terms of sort of spruiking the LRSJ, if you are interested in things like Asia Pacific studies, or you have a particular area expertise, we do have projects that are working in the region. We've had projects working in the Pacific region, legal aid programs. We currently have a group that's working with the Center for Social Justice in Gujarat, in India, working on Adivasi and Dalit rights and access to justice. So these will attract students usually who are doing something else with their degree. But it may be that your interest is in international economic law or trade law or something. There's social justice and law reform issues in that area as well. So you can bring your other areas of interest and passion into this program. Are there any more questions before we finish up for the evening? We have one more at the back there.
Thank you everyone for speaking today. It's been clear, especially in the media recently, and even today, the strategic environment is becoming quite challenging. I just wanted to ask, do you think that the security benefits to Australia of getting the RAA across the line more quickly, as it is now, outweigh the issues that have been raised today? Or do you think it's necessary to reevaluate the treaty, understanding that this will take probably quite a long time to actually get through?
Yeah, so that was something that, at least in terms of the death penalty section, that I sort of had in my mind as I was researching and writing it. Like, yeah, at what point does the probably fairly unlikely chance that an ADF member would be subject to the death penalty get outweighed by the benefit of the treaty itself? And I'm not sure what the answer is to that question, and perhaps some of the other panelists can talk to that. But that was part of the reason why we provided multiple different possible changes to the treaty that would still allow it to ultimately be ratified and passed and have the positive impacts of the treaty in the current security climate, but also providing a greater level of protection for ADF troops. So yeah, it's a fine balancing act, and hopefully there could be changes to the treaty that wouldn't impact its ability to be ratified and to go into effect.
I think one could argue that this was a necessary compromise, but then if that's the case, then the Australian 2018 strategy should no longer be there. I don't have a problem if Australia was simply just an abolitionist government, a treaty to second optional protocol. They don't execute in their own country, they don't extradite individuals, but they make compromises. And if that is the decision by the Australian government, fine. But they did have back then the 2018 strategy, and that is having a cake and eating it. So that would be my answer to your question.
Okay, well, I think we've pretty much come to the end of our time here. It's exactly 31 minutes past the hour. So thank you so much to the panelists for your insights. Thank you especially to the students for your contributions, which I know you do voluntarily. Dr. Sato for coming in from Melbourne and meeting with students, and Don for bringing this whole event to fruition, because it was Don's idea to showcase what our students have been doing. Will you please join me in thanking our panelists?